in order to establish justice, did ordain and establish a Constitution for the United States of America. The Constitution is also supposed to ensure domestic tranquility. From the Constitution, the law of the land flows, but sometimes we come up against the law and just don't know what to do. I'm Sidel Pitas, and from time to time we talk about legal problems that affect us all. Tonight we're going to talk about what happens when we come up against the law in a dispute with our neighbor. Now with me are Maura L. Sheehan, who is an attorney, and attorney Patricia S. Nelson. And they both practice in Lexington, Massachusetts, but the problems we're going to talk about really apply to all over New England. Now, although the three of us are lawyers, what you hear today is not legal advice to you. For that, you have to take your specific facts to your own legal counselor. Now, before Pat and Maura start telling us about, boundary lines that move and barking dogs and smelly things on your neighbor's property and all kinds of nuisances that disturb the domestic tranquility, we're going to hear what the world-renowned poet Robert Frost had to say about neighborly relations. Here's Tony Kerrigan reading parts of Mending Wall.
Something there is that doesn't love a wall, that sends the frozen groundswell under it and makes gaps that even two can pass abreast. No one has seen them or heard them made, but at spring mending time we find them there. I let my neighbor know beyond the hill, and on a day we meet to walk the line and set the wall between us once again. There where it is, we do not need the wall. He is all pine, and I am apple orchard. My apple trees will never get across and eat the cones under his pines, I tell him. He only says, good fences make good neighbors. Spring is the mischief in me, and I wonder if I could put a notion in his head. Why do good fences make good neighbors? Isn't it where there are cows? But here there are no cows. Before I built a wall, I'd ask to know what I was walling in or walling out, and to whom I was like to give offense. Something there is that doesn't love a wall, that wants it down. But he will not go behind his father's saying, and he likes having thoughts of it so well he says it again. Good fences make good neighbors.
My husband says the reason we have so many lovely stone walls in New England is this. Think of two farmers clearing their stony plots. After all, this is New England. Clearing their stony plots, and each of them has these boulders, and what are they going to do with these rocks? Now, if they were to put them on their neighbor's property, that wouldn't work because it's not the neighborly thing to do, and also because the neighbor would just throw the rocks back on your side of the property. So they piled the rocks down the center and came up with those lovely boundary stone walls. Now, the problem is, over the centuries, those stone walls have disappeared, been moved, whatever, and the descriptions, the property descriptions, still use them, or they're just approximate. And so we have a lot of boundary disputes here in New England. Don't we, Pat?
In fact, most people don't really know where their boundaries are. Tonight I'd like to bring an example that's not true, it's fictional, but it's very typical of a boundary dispute and a dispute between neighbors. Neighbor 2 is moving into an existing neighborhood. She bought a lovely home, and at the time she bought her property, she gave a lot of thought to it. She bought the house, but she didn't have her boundary lines surveyed. This is absolutely very typical because it's so expensive to have an instrument survey done.
What's an instrument survey?
An instrument survey is what we think of as surveyors doing. They go out on the street and you'll see the surveyors with their tripods, using their instruments and sighting the lines. That gives us a very accurate line. And typically the surveyor then goes out and stakes the line on the ground. And I think most people have seen the wooden stakes with the pieces of orange cloth or orange painted at the top of them to mark the line of the property.
So it's really an imaginary boundary line, like if we had stakes down the center of our studio floor here, right?
Well, and in fact, once the surveyor staked it, it's not so imaginary anymore. Now you can actually see it, but until the surveyor stakes it, in fact, the line to most people is not visible at all. And because of the expense involved in doing this, most people only have a plot plan done, which isn't very accurate because it's a tape survey, not one done with instruments, and it's also not on the ground. And most of us can't look at a plot plan and imagine where the line is on the ground. So neighbor 2 has bought this house, she's moved in, she has children and decides to put up her fence. And as her lawyer told her when she put up her fence, she said, I had better have that line surveyed to make sure that I put my fence exactly where it ought to be. So the surveyor comes out, goes over, puts the stakes on the ground, and lo and behold, it's not where she thought it was. It's not on the hedge, on the edge of her line.
Okay, so when she went to buy this property, she looked at it and there was a hedge between her and her neighbor. This fence, for example, pretend it's a hedge, okay? So the hedge is what she saw, and she assumed that that was the boundary line between her and her neighbor.
That's right.
Okay, she goes and she has the survey done, and what does she find out is her property line?
Well, the surveyor comes out and puts a stake of lines, not at the hedge, but over on what she thought was neighbor 2's land. And in fact, it goes right through the middle of a beautifully landscaped garden.
Neighbor 2 probably thought that was his land too.
Neighbor,
neighbor 1, the one who was
neighbor
there
1,
at the start.
Yes, thank
okay.
you. Neighbor 1 is furious. Neighbor 1 comes out and tells the surveyor to get off his land, said, this is my land, you can't put these stakes here, and he starts to tear the stakes out. Well, neighbor 2, it's just moved into this neighborhood and done the survey, is just furious as well, and tells him to get off her property and insists that she's going to call the police.
I think I see the beginning of a neighbor dispute here. So what happens? What do they do?
Well, as in all neighborly disputes, the first thing is to stay cool. Because when you talk about property, people become very emotionally vested. And the first thing to do is sit back and evaluate just how important it is to you. If it's something that is extremely important, then your ranges of options start with talking with the neighbor. If that does not produce the results that you hope for, then I would advise to consult a lawyer and see if the lawyer can help you to mediate where's the middle ground. Because if you feel that you want to bring a lawsuit and go for the litigation route, you're talking a long time and a lot of money. And so you have to really evaluate what you want from this.
But here, how are you going to mediate this? Oh, go ahead, Pat. Tell us some more about it.
Well, I think it's important for people to realize that there are many options and that there are many ways to resolve a dispute like this, short of going to court or even after you've started a lawsuit. And the options include working out some agreement whereby the other person is allowed to maintain their garden on the property, some sort of written agreement, which we might call an easement to maintain a garden without taking the property away from the person who owns it.
Now, why should neighbor 2 mediate? Hasn't she got the law on her side? She had a survey done, and she found out that her property line isn't here. It's over here. That's what she bought. Doesn't she have the right to own it? What's the argument on the other side?
Well, neighbor 1 may have what's called an adverse possession argument. Neighbor 1 may have been using that land for over 20 years and using that land in an open fashion, in a sense to say this is my land to the rest of the world. So if there is a legal dispute, neighbor one may have a strong adverse possession claim, and that would be the subject of litigation.
Of course, adverse possession claims are very difficult to establish and actually pull off.
Right.
You not only have to show that it was open, but you have to show that it was notorious, and these are
Notorious meaning everybody knew about it. It was well known.
and not just done in the middle of the night, that's
Okay.
right. And it also needs to be done in a manner that's adverse. They have to show that it wasn't just done with the permission of the neighbor or somehow by mistake. So these adverse possession claims are often hotly contested and at great length and expense.
And it must be a continuous 20 years. So if there's an interrupting time, the clock stops ticking. And all of these matters have to be proven in litigation if you go to litigation, and that is a serious undertaking.
And all because she wanted to build a fence.
And all because she wanted to build a fence. But there are things people can do, there are steps people can take if they consult a lawyer, if they try and focus on it with a problem solving rather than an angry point of view. There are things that can be done and that need to be done once this difficulty over the boundary has come to the party's attention. The worst thing people can do is to do nothing, wouldn't you say?
Yes, and even if the parties come to an agreement on their own, it is advisable to consult with a lawyer so that that agreement can be memorialized in writing and tucked away so that, 5 years later, if someone has a different recollection of what we came to agreement on, you have a document to refer to, and that removes some of the anxiety.
Oh, worse, when you have an issue that has to do with land, if the document is not in writing, it may not be enforceable. And if it's not recorded in the registry of deeds, you may not have any rights when another neighbor moves into and buys that house next door. So it's very important that the parties
Okay.
consult a lawyer.
You've got to get your survey done. You should consult a lawyer. It doesn't necessarily mean a lawsuit, but you should try and talk and work it out. There are lots of ways of dividing a property along a boundary line, or we hope along a boundary line. Lots of different kinds of fences and barriers. Let's look at some and see if we can tell what the problems are that may arise because of the fence between two neighbors.
Well, as you can see here, this fence looks as it may be in some disrepair. And so as you're maintaining a fence, it's important that here, as you can see, someone could be hurt by that fence, that you keep your fence up and that you maintain it so that no one would be injured by the fence.
Now, this is not a particularly attractive barrier. What do you think they're trying to do there?
It appears as though that may have been put exactly on the property line.
Because of that little jog, so somebody was really figuring it out to the inch. There, we passed there, and here we have it in slightly better repair, but we have 3 different kinds of fences in one picture.
Yes, well, most towns don't have architectural controls on fences or anything else, unless you live in an historic district in a town where you would have to get approval for erecting a fence of any particular style, or unless you have restrictions in your deed. There are some subdivisions that have restrictions in deed that require the approval of either a developer or a neighborhood committee, even once the house is up, in order to be able to build a fence or any other kind of structure on the property.
Likewise, many zoning bylaws will regulate the height of a fence.
Now, we saw there some pictures of plants growing through fences. They're growing through a stone wall or growing through another fence. We've had lots of questions about what happens if you have a plant on one side of the fence and it grows through to the neighbor's property.
Oh gee, this can get very, very complicated and problematic. It really depends upon where the lot line is and who owns the fence and whose side of the lot line the fence is on and whose side of the lot line the flowers are on. I think the basic rule is that if the flowers are growing onto your land, and over the lot line and onto your land, then you can remove them.
Okay, so we saw a sort of an unruly hedge, and it's possible that you could have a nice neat hedge on one side of a property line and a raggedy one on the other side.
Absolutely true. I think once again, though, the best and the first rule for all of these kinds of problems is to talk to your neighbor first.
Maybe you can jointly hire a gardener or take turns mowing the lawn or something. Now, what are we looking at here? I think we saw a shared driveway before. There was a driveway in between two properties, and that's not an unusual sight here. Can you think of any problems that can happen in that regard?
Well, I think anyone buying a house with a shared driveway ought to look closely into the problem and the issue. Very often, these shared driveways are handled through written documents that spell out the rights and responsibilities of the parties. And if you're buying a house with a shared driveway, you're going to want to know what those rights and responsibilities are before you buy. Even worse, there might be no written agreement, and the parties and rights and responsibilities might be vague and unset out, and that often leads to problems.
Now, we also saw there a fence around a pool, a swimming pool.
Yes.
That's one area that's highly regulated,
Yes,
isn't it?
and that's really where a fence is required. Zoning bylaws require that the owner of a pool have a fence that is locked when not in use. It's also a matter of if you have a dog, sometimes a fence is a very good thing to protect you from liability and to keep your dog on your property. So fences can serve excellent purposes.
Now, the sign that was on that pool fence happened to say, "Beware of dog."
Mm-hmm.
And that just happens to get us into our next topic, which is some kinds of nuisances that happen between neighbors that you just can't fence out, that a 10-foot stockade wouldn't take care of. What are some of those nuisances?
Well, nuisances generally fall into 4 or 5 categories. Pets are often the cause of a nuisance, mostly because they make noise, a second cause of nuisance. Odors, if someone's burning something on their property, that can be a nuisance. If someone is conducting a business on their property, such as having yard sales or conducting their own private practices without proper authorization and parking, that can be a nuisance, as well as just the notion of keeping your property unsightly, having junk cars or having what might be called, and often in the zoning bylaws is called a junkyard, such that people are bothered by it. It is a nuisance to them, and it interferes with their enjoyment of their property, and that's the essence of what a nuisance is.
Well, let's start with those dogs. Barking, barking, barking. This fence here is not going to keep out the noise of a barking dog. Can anything be done about it, really?
Oh, there's a great deal that can be done. First of all, if the dog is simply annoying, once again, the first step is to talk to your neighbor and see if there's any way that you can work out a problem directly. But people need to know that if that doesn't solve the problem, they can turn to people in their town or city and seek a solution. Animal control officers have a great deal of authority and responsibility for dealing with dogs who are annoying, dangerous, a nuisance of any kind. And it's important that people know that they can call their animal control officer and seek a solution that way. What if that fails?
Well, that solution, too, can range from muzzling. An animal control officer can order someone to muzzle their dog for the noise. Fining. You can actually get a restraining order against a dog who's bothering another animal. If all of those measures fail, you can go to the chief of police of your town and make a written request that the dog be removed. And certainly, if there is danger, if you are a person who owns a dog who is the offending dog, there is strict liability, which means that if your dog bites somebody, you are responsible legally and you have no justification. And that's very serious. If your dog bites a child under the age of 7, not only are you responsible, but the law will extract triple damages from you. And so that fence could save you.
Now, a dog bite can be proven. But dog barking and lots of other kinds of nuisance, like the unsightly mess that you mentioned, those are hard to prove. That is, your neighbor could maybe clean up if they know that the health inspector is coming to look at it, or how do you show that the dog is barking? What kinds of evidence are you going to produce?
Well, I do think it's important, Sidel, that people get the facts if they're going to make a complaint, or even if they're just going to talk to their lawyer about the problem. And getting the facts can include everything from making tape recordings of the barking of the dog, keeping a log that might show the date and the time of the barking, and when it occurred and the duration of the barking. If your problem is one of the other nuisances we're talking about, you would have similar problems. If you've got junk cars on the street, you could take a photograph. So getting the facts, documenting the facts, writing down times, tape recording sounds, those are all things that can be done and will significantly help a person who is making a complaint.
The other suggestion I would have is getting a sense of if there is a community consensus that this is a problem, so that if the other abutters also feel the way you do, that you're not perceived as someone who's just highly sensitive, but this is an issue that the community has to deal with. And when you go before the local regulatory authority, if you have supporting neighbors, your case will always be stronger.
Now, I noticed that neither of you really talking about go get 'em, kill 'em kind of court fight, and yet, you know, you're lawyers. Isn't that what you tell your client? Well, you're right, and all you have to do is pay me and I'll prove it.
The first thing I tell my clients is how expensive, not only in terms of the legal fees, but in terms of the emotional wear and tear, litigation is on the parties to that litigation. Litigation is a last resort only. People should consult their lawyer because their lawyer should, and lawyers generally do offer them solutions short of litigation first, and people should explore those things. One of the things that I'm most concerned about and interested in is the prospect of using mediators as a way to solve problems. Mediators are trained lawyers or trained community representatives who are available, sometimes on a pro bono basis and in other cases on a fee basis, to step in and seek solutions between parties. And those solutions, because they're voluntary, they're agreed upon between the parties, and because they are flexible, much more flexible than the courts, as well as much less expensive, can often do so much more for the parties than going to court. So there are solutions out there and people need to explore them.
Now, what happens if you try to mediate and it doesn't work? You litigate and you get a solution, a legal solution of some kind, but these two parties still have to go on living next door to each other.
And I think that goes to the essence of litigation versus mediation. With proper mediation, both parties come out feeling as if they got something, that they achieved some of their goals. Maybe gave a bit, but got something. With litigation, there's a winner and a loser. And the winner has to live next door to the loser, as you said. So, but and I will say, though, that there are times when litigation is required. For example, if you need to clear a title issue, if you're planning to sell your house, you cannot wait for mediation, or you need an immediate answer. Likewise, if there's some level of harassment, or if there's any feeling of a physical threat between you and your neighbor, you may need to have litigation. The other point with litigation is it can be used in conjunction with mediation when there is a legal question that must be answered, and you can turn to the court for the legal answer and then bring it back to mediation. And sometimes just initiating litigation will bring the parties to the table.
In fact, sometimes you have to start a lawsuit to get the other party to the table.
There's a kind of a nuisance that is difficult to document. You can't tape it, and it's smells. Have you ever had situations where smell was a nuisance?
Well, oftentimes when people are burning leaves, they may put things into the burning leaves that may not be leaves, and that can create a smell. Typically, each town's zoning bylaw will address, will prohibit noxious fumes and odors, such that if this is something, if on one Sunday afternoon your neighbor burns something that smells, walk on over and talk about it. If every day something is going on over there, you can seek remedy through your zoning bylaw, through the building inspector in your town, through the people who enforce the zoning laws, and ask them to step in and help you out.
The Department of Health has something to do with this?
Or the Department of Public Works, or as well as in certain situations, the Department of Environmental Protection, if it is something that is potentially an environmental hazard.
Okay, and you mentioned improper use of property. What do you mean? It's my house, my yard. Can I use it the way I want to?
Oh, absolutely not. We live in a regulated society, and our zoning bylaws typically have use regulations which significantly restrict the uses a property may be put to, particularly so in residential areas. And in those residential areas, various kinds of commercial activity are normally prohibited, and people need to look at and look to their own zoning bylaws to find out what they can do on their lot in their part of town.
Well, you know, everybody's got a home office, right, these days? So, what do you do about that? I mean, you don't want to just go squeal on your neighbor.
Well, the zoning bylaw is usually quite specific about a home office. It will say if the person who lives in the home may have the home office and maybe have one client at a time. Parking is really what dictates some of the issues related to a home office, because your neighbors should not bear the burden of 20 cars lined up in front of your home business. In terms of other uses, I think one of the hottest topics right now is the yard sale that is not every once a year, but becomes the every Saturday afternoon yard sale. And many towns are dealing with that, addressing that as we speak. That's something that certainly will come under more heavy regulation as time goes by.
You know, you mentioned how towns are dealing with things, and there are the boards of health or the animal officers, but with neighbors, the officers are also their neighbors, right? So you get a lot of politics going on, but friendly kinds of politics. Any way around that?
Make friends.
Make friends. That's a good idea. Let me ask you something. Suppose you've tried everything. You've been reasonable with your neighbor. You've called the right officers. You've even taken them to court, and just run out of money so that you can't finish the litigation. You're at your wit's end, can't think of anything else that you're going to do with your recalcitrant neighbor across that beautiful fence. What are you going to do?
Move!
I hope that you found our program entertaining as well as educational. Let us know what you think. Write to us at Media 1, 80 Skillings Road in Winchester, 01890, or call me, Sidel Pitas, 617-721-6800. And we'd like to know what kinds of problems you come up against the law with, and we'll deal with them on future shows. Bye for now.